Hello to everyone. We are ready to go to talk today about freedom of expression in the United States. I told you in the last classes that I will do a special introduction to freedom of expression in the United States. A lot of people exercise their right to free speech. Maybe we need a little bit more calm. Okay, I did announce that we will talk about free speech in the United States because it's a system which is quite different from the one under international human rights law or also in many continental jurisdictions, also different from Canada. And by the way, I also wanted to mention that we put online some reading about the United States and freedom of expression, which you don't have to read, but it's from the New York Times, just to give a bit more context. Here we are looking at it from a more doctrinal point of view. How has free speech evolved? What are the principles the Supreme Court applies? But I think it's also important to take into account the social context, the political context, which at the moment is not very free speech favorable. So we put an article online for those who are interested, not necessary to read for the exam. So today the purpose would be that we also understand the historical context in which current free speech doctrine in the United States evolved, and then get an overview of how freedom of speech is protected in the US. I can't look at all the intricacies, so it's really an overview of the main, I would say, approach the court takes. And we will later on read more cases throughout the courts. So, but I think you should have with this course a bit, kind of a compass which helps you to navigate through the system of free speech. Now, I think we already read the Schenck case, remember, last week, and it's really within the context of World War I that we have the first significant free speech cases, and also important, the law as it stood at the time was really not very free speech friendly. You had these acts called the Espionage Act, the Sedition Act, which foresaw really quite strict penalties. I told you could go 20 years to jail for having had statements which could have the aim of overthrowing the government, etc. So draconian laws in place and challenges coming under the First Amendment. We read the Schenck case saying, basically there was no violation of free speech, saying the nation is at war, etc. And basically when we look at the case law, also Abrams, Whitney, etc., and there were other cases, it was always free speech cases targeting communist socialists. There was criticism in legal doctrine from an author I mentioned last time as well, Zachariah Jaffe, who basically said the Supreme Court was not protective enough of free speech. And Jaffe knew particularly Justice Holmes, so Justice Holmes' reversal in a way or approach then basically militating for a stronger free speech protection is said to be linked also to his conversations with Zachariah Jaffe. So we start having dissenting, concurring opinions of Holmes and Brandeis saying, well, stronger protection for freedom of expression. Then if we move to World War II, we are again in a context where freedom of expression got quite strongly limited. I think it often happens when you're at a wartime. And again, I put online this poster just to show to you nowadays when we talk about communism, it may not appear to us with so much historic distance as a big threat. But at the time, already during World War I, it was sometimes called that time the first Red Scare. There was fear of communism, and the World War II and that time also called the second Red Scare. And I'm just mentioning it's always easy with hindsight to criticize, but sometimes when you are within the system, when we talk about my home country, Switzerland, they maybe didn't clamp down on free speech as much, but we had a huge privacy scandal where the government basically had files, about, I can't remember how many, 500,000 or more citizens. It was sometimes enough to go on holiday to Central European countries, and you were basically, there was a file about you. So here, to return to the US, we are in World War II. We had then also, there was the so-called Smith Act adopted, also called the Foreigner Registration Act. So basically there was also, first of all, foreigners all had to register. So you could see also this idea, if you're a foreigner, you might be a threat, typical of wartime. And there were again penalties for, wanting to overthrow a speech which could be meant to, as aimed at the government. Then a bit later, 1947 till about 56, 57, we have McCarthyism. Who knows what McCarthyism is? Who's heard about it? I can see someone. Would you like to say what McCarthyism was? Or I am depriving you of your right to food. That's not very kind of me.
I'm not sure I could describe it. I've heard.
You've heard about it? Anyone else has any? Yes?
I'm not 100% sure, but I think it was a very strict policy, like anti-communist policy that the United States was practicing at the time, where they were trying to search for anyone who had communist ties, and where I heard it most in the context of Hollywood. There was a lot of a blacklist of Hollywood actors or directors who were suspected of being pro-communist, and so they were blacklisted.
So I think you've described the phenomenon quite well. Some people talked about a kind of witch hunt, even named after Senator McCarthy. Basically, the idea was you really did, it was a kind of a process, also a vetting, clearing process. You didn't want to be a communist or a socialist. So that affected, you mentioned Hollywood. There was a list, I think, of about 300 actors. And Charlie Chaplin, for example, was on that list, so that's when he also left the United States. You had also, when you wanted to work for the government, they were so-called loyalty boards. So people would ask you a lot of questions about, these boards, what are your political beliefs, etc. And if you were considered as not loyal, so you had socialist thoughts and so on, you could not work for the government, and generally it had broader effects. So some people, basically, I remember one quote saying basically, if you were ruined forever, if you were found to be unloyal, no one else wanted to hire you, etc. So quite a lot of ostracism. Maybe just about McCarthyism, has anyone seen the film Oppenheimer? So there you see at the end that he also has trouble under McCarthyism for being considered too left-wing, etc. So that's an illustration of McCarthyism. Now, and it's also interesting, I've been seeing in the press that some commentators say maybe we are back at a time like under McCarthyism. But nowadays, the clampdown we have on freedom of expression in the US, is it something like McCarthyism? I think we will see. The jury is out there, but we're certainly in a context where it was basically the statements I read were mainly after, the murder of Kirk, that then they've also denounced people who were critical of him, etc., so that you can create a climate which basically leads to a lot of restriction on freedom of expression. And don't get me wrong, I certainly don't approve of any murders of anyone. No. But if you then overshoot and basically go and target anyone who may have been critical of that person in the past, that certainly is detrimental to freedom of expression. Then what did the Supreme Court do? If you return to the 40s, the 50s, basically you had different camps, I would say, or strands within the Supreme Court. You had, on the one hand, some justices like Black and Douglas, who were free speech absolutists, basically saying, if you read the First Amendment, and we talked about the importance of also how human rights guarantee is labeled, there is no limitation clause. So they basically said, well, free speech is absolute. Now you may say, well, that's maybe a hard position to hold, so their way out was to say, well, we have to distinguish between speech and conduct. And probably they would label conduct some statements like, direct incitement. If you incite someone directly to murder someone or so, it would have probably been conduct. We will read next week, you will read the case Brandenburg versus Ohio, and you have a concurring opinion by Black and Douglas. And when you read it, you will see it's a free speech absolutist approach. They reject a present danger test or any other limitation of free speech, saying it gets distorted too easily, just due to the political circumstances. Then there were other justices, often associated with the justices, that campus, Frankfurter and Harlan, which basically said, no, freedom of expression should be balanced against other interests. Now, the terminology used in the US here is ad hoc balancing. Why ad hoc? Meaning you take one case at a time. That approach is considered as not being free speech protective enough, and I think when you did the reading for today, maybe the Brown case, it transpires. What we have nowadays, we don't have free speech absolutism, so the Supreme Court does not claim free speech is absolute. But it rejects ad hoc balancing. It basically tends to find approaches where you have what is sometimes called definitional balancing, for example, which consists of categorizing expression. For example, we will talk about defamation. That's the case here, New York Times versus Sullivan, where the court will say, if we have defamation cases, this is how we handle the conflict between free speech and reputation for the whole category, not one case at a time. Or Chaplinsky, a case we'll talk about also today, is to say some categories of expression are unprotected. So it's the idea, don't take one case at a time, try through categorization to create, I would say, more foreseeability and reduce judicial discretion. Now, as obviously the Supreme Court plays an important role, I just would like to say a few words about the Supreme Court. When you read about the Supreme Court, you will often have references to, for example, the Warren Court, the Burger Court, etc. That's always the name of the Chief Justice. So the Chief Justice is the one who presides the hearings in the court, who will also, for example, decide which justice writes the opinion. That has some concrete impact. Who do you entrust, with writing the opinion of the majority? And when we look at these different courts, so we will be reading cases from the Warren Court, New York Times versus Sullivan, a seminal case on defamation. The Warren Court was in the context also of desegregation and the civil rights movement. And quite a few cases at the time were brought against, people who were demonstrating, for example, for civil rights, advocating for civil rights. New York Times versus Sullivan fits into this category. And you can see the Supreme Court being cautious here to protect a liberal court, free speech being restricted. Then the Chief Justice Burger was actually a conservative justice. But what is interesting, that sometimes you pick a justice thinking he's conservative or he's liberal, but sometimes they have their independence, so they can change their mind, they can evolve. On the Justice Burger, that's not a free speech case, but an important case, Roe versus Wade was decided. It's this famous case on abortion, which basically liberalized abortion, but almost to the end of the pregnancy. Case now overruled by the current Supreme Court. After the Burger Court, the Rehnquist Court, we have again with Rehnquist the conservative Chief Justice, the Supreme Court was in a way split. 4 liberals, 4 conservatives, Kennedy a bit in the middle called the swing voter. And we will read 2 cases on freedom of religion, decided on the same day on relatively similar issues. Can you put up the 10 commandments in public space? Where you have one justice changed camp. So once the opinion is written by the liberal justice, a liberal justice, and once by a conservative. And we will be discussing, are these cases actually, is it just a political difference, or can you say legally it makes sense to distinguish them? But at that period we had a bit of a balance. You did not know always, which way the case would go. Now with the Roberts Court, people say it's kind of one of the most a very conservative tendency, maybe the most conservative for quite some time. If we look at the court, you can see now that basically there are 3 liberal justices appointed by, I always put also which president appointed them, and 6 conservative justices. So basically the conservatives now have a majority. Also important, maybe just for the US Supreme Court, I think most of you know that the justices are appointed for life. There is some discussion, is that a good solution or not? And it's a bit this, that the justices may hang in there. Sometimes they wait for a new president to be elected, thinking, well, let's hope it will be a president of my ideological leaning who will appoint the next, my successor. Didn't always work. Think of Ruth Bader. I think, for example, Ruth Bader Ginsburg, some people said she should have retired earlier. She was under Obama still, but well, she stayed on. But I would say this system, as I view it, I know what you think about it, the risk is that it does favor maybe a more politicization, because it is a question of timing. It's very important which president will nominate the next justice, and once the person has been appointed, they might stay there for decades. Whereas most systems have rather, I don't know what it's like in your home jurisdictions, often it's a fixed term. 9 years, 16 years, 12 years, etc. Switzerland is a bit special with 6-year term, which is very short, and the possibility, which is quite special as well, that our justices can be re-elected. Maybe not ideal from the point of view of judicial independence. Appointment of the Supreme Court, it's always the president which makes the suggestion, but with advice and consent of the Senate. So you may, I don't know if any of you ever watched any selection process of a Supreme Court justice. Anyone did also? It's really, they will look at everything the person has ever written. And they will really try and find out as much about you. Why did you, what will you decide on Roe versus Wade if that comes to the bench, etc. So it's a very thorough process, because it is of such importance, because you will have justices who will stay there basically for decades if they want. So I would say also some politicization of this whole process. And maybe just about what the Supreme Court does also, it's a Supreme Court, not a constitutional court. So its main aim is also to oversee that federal law is applied in a uniform manner. And that does include the Constitution, but it's not limited to the Constitution. The court receives thousands of applications per year, 8,000 or more, but it can select the cases it wants to hear. For example, a system we don't have in Switzerland. It's considered a right, to appeal to the Supreme Court. Obviously, there are conditions, but our Supreme Court, for example, can't pick and choose. Here, maybe the court will hear 80 cases a year. So 1 out of 100, the idea being you don't so much render individual justice, but the function is to decide, unify the approach of lower courts on important cases. As regards constitutional review, you may know that it's a decentralized, a so-called diffuse system. So any lower court could, for example, refuse to apply an act of Congress saying this act is unconstitutional. The idea being at some point it will find its way to the Supreme Court, and the Supreme Court will say whether that's correct or not. Quite different from the continental system of constitutional courts, which often have a concentrated review where you'll say it's only the constitutional court which can decide if an act of parliament is constitutional and set it aside. Now, what is also quite interesting sociologically speaking, if I ask people, are there people, who are the Swiss scholars here, the Swiss students, if I ask you to name some justices at our Tribunal Fédéral, how many names come to anyone? And I think that's not surprising. So, for example, our Supreme Court is quite anonymous. Almost 40 justices, no one knows them, no dissenting opinions, etc. In the US, it's quite different. 9 justices, and there's a lot of analysis of each of them, and from all different kinds of view. Yeah, we've already mentioned that. And I found, for example, studies of what is the political leaning of the individual justices. You'd never find anything like that in Switzerland. And you can see, for example, here, that's where we stand now. So you have the liberal justices here, and then you can see, apparently at the moment, Justice Thomas, the most conservative one. Then I also found some studies about how is the Supreme Court considered at the moment. And I thought it was interesting that at the moment the consideration, the respect the court gets is, according to studies, at a historic low. I think for a long time, I mean, the Supreme Court in the United States inspired quite a lot of respect. And I would say that in the recent years, quite some, it's become, you can also see this polarization between that it's strongly politicized, between Democrats being only 26% approve of the court, Republicans are 71% approval. So we will see how that will evolve. But I think it's always interesting also as lawyers to take into account the social, the political context, not just be black letter lawyers. Any questions so far? Yes?
Could you go one slide back?
Yes, I can.
It was really interesting. What happened to Douglas?
Where is he? I don't know. It's a good question.
Not a name that rings a bell, and it looks like he became very liberal, very silent.
I don't know, it's an interesting question. I should do some research on that. But it's also interesting, basically, that justices, even if they are, selected based on political motives, because they are independent, they may evolve. So that happened also with the Burger Court, as I mentioned, where they thought, okay, we had the Warren Court, oh my God, now we have a bit of conservative court. And what do they do? Roe versus Wade. Maybe we should check if there are some psychological studies. I'm sure there are. So I'll move on. Now, if we look at freedom of expression, I already mentioned it, that it's an approach which is mainly based on categorization and rules, in the sense that the court does want to avoid as much as possible ad hoc balancing and wants to create a system which is quite foreseeable and favorable to freedom of expression. And we will see basically 2 major distinctions or categorizations the court does, and both are very important. One is based on the value of the expression. We will see what these categories are. But also, the court looks at the aim and the nature of this restriction. So the measure which limits freedom of expression, there's a distinction we will look at. And some measures are more suspect than others. So the court will, in some cases, say, ooh, this type of measures are basically hardly ever admissible, and others, the court is more lenient. I've mentioned the skepticism of ad hoc balancing, and I'll give you in a while some more examples on that. And I think from a European point of view, the system is relatively complex because we do have these general categorizations, but the court also develops special rules for special settings. I have some examples at the end of the class on the last slide. So we will see there's a special test for subversive speech. Is it a clear and present danger? The court will have special rules for example, for people who work for the government, for the school setting. So you always have to kind of know which setting are we in. Is there a special test we apply? If not, it's the general system of categorization I will present to you. And last feature also, I already mentioned it last time, that the conception of freedom of expression, it's a negative right. It applies to state action. It doesn't apply, for example, to private companies. And I mentioned these two cases. It's the cases in which basically, I think Florida and Texas adopted laws which were aimed at prohibiting social platforms, Facebook and company, from moderating content. And the Supreme Court basically said free speech does not apply to them. They are private actors. They are like a newspaper. They decide what they want to publish. It's not up to the government here to say we have to protect freedom of expression against limitation by Facebook and company. And interesting, I mean, here, because I think sometimes we can oversimplify and say, it's just all political decisions. It's still decisions, here cases decided by the current court, which is more conservative, but these laws actually were proposed by conservatives, by Republicans in Texas and in Florida, saying social platforms, they censor too much conservative speech. They should not. And yet the Supreme Court said, no, it's basically not state action. I mentioned the skepticism against ad hoc balancing, and I have here on the slides two cases. The second one is quoted in the Brown case you read for today. The first case, the court tells us, in light of the substantial and expansive threats to free expression posed by content-based restrictions, this court has rejected as startling and dangerous a free-floating test for First Amendment coverage based on an ad hoc balancing of relative social costs and benefits. So we don't want to do ad hoc balancing, free-floating, no one knows which way the cookie crumbles. That's not what we're going to do. And also then in United States versus Stevens, the First Amendment itself reflects a judgment of the American people that the benefits of its restrictions on the government outweigh the costs. That's quite a general, a sweeping statement to say, in a way, well, the Constitution and its founding fathers already made the balancing in a way, saying free speech should outweigh the costs. I'm not sure a European court would make such a general statement on freedom of expression. Now, I was talking about this approach consisting of categorizing expression. So a first distinction established in the case law is between so-called high-value speech and low-value speech. The question now obviously is what is in what category? What would you put in high-value speech if you had now, if I asked you to do a categorization? What would you... Religious opinions, I think, so on religious matters or so, partly they would probably be already protected by freedom of religion, but yeah, you could say it has any other ideas? Or what would you put in low-value speech?
Low-value those that incitement violence.
Incitement to violence, you would
Yes.
say? That would certainly could be put there. High-value speech, other things apart from religion?
some promises,
Mhm.
but maybe you know it's violation of somebody else, you know, rights, but it doesn't count under the phrase speech, or you cannot file a case against that speeches or
Okay.
their promises.
So that's an interesting example you're giving. If I'm a politician and I make promises during the campaign, I know I don't want to. Think of an example, Brexit. Oh, you know, all the money we will save here, we give to the EU will give to, what was it, the NHS. You have no intention of doing so. Typically, as you say, there's no action against that. So basically, I would say high-value speech with quite a strong convergence between different jurisdictions, that political speech is in there. Also because the experience shows that there will always be a tendency to restrict free speech, particularly of your opponents, obviously. Government in place may not want to be challenged by others. So basically, you could say political speech generally considered high-value speech. And that's also an idea. The US Supreme Court always says that political speech is in a way at the core of the First Amendment. But high-value speech is not just political speech. It's in a way a residual category. Anything which is not low-value speech will be put in the higher category. Yes?
I would say academics and academic publication would be high-value speech.
Oh, I love that one, of course. Whatever. No, I would say generally that would also be within high-value speech. Again, I think for different reasons we discussed that often it's also minority views which favor progress. And I think you could maybe just also ask yourself who are the actors who get targeted quite strongly when you have illiberal tendencies. Academics are among them, artists. The comedians, we've seen it just recently, satire, etc. The media, journalism, universities are among the targets as well. When we turn now to the US, just important to bear in mind, if you look at high-value speech, and here I have an excerpt from a case where we can see that basically the court says, accordingly, speech on public issues occupies the highest rung of the hierarchy of the First Amendment. And it's not political speech just in a narrow sense, but it can be also, someone mentioned religious things. So if you make a comment about religion or political, social, or other issues important for the community, that would... the idea being it's not just in a private interest that the statement was made. So that would be for the court really the speech which needs the strongest protection. But, and it's important to repeat it, the methodological approach is to say anything which is not low-value speech is high-value speech. So it's not limited strictly to political speech, but political speech broadly understood would be really what we say. Here we have the value of democracy. Now, just to give you still, it's interesting, Snyder versus Phelps, what that was about. But I think that case may show also some divergences from, specificities of the US approach. It was basically a funeral. A soldier who had died in Iraq, he was homosexual, he had his funeral. And outside, basically, the funeral facilities, there were demonstrations of people against homosexuality. And so they were, shouting slogans, etc., like I will read them to you. So they were singing, "Thank God for dead soldiers, facts doom nations, America is doomed, priests rape boys, you're going to hell." Imagine you're the family and you have outside, you have these demonstrations. And basically, the Supreme Court still felt that this is high-value speech. It's an opinion on homosexuality, so found a violation of freedom of expression. Now, I can't remember what the statute said it applied. There is a way, we will see it later, around it. If you want to avoid this from occurring, you would have a general law saying there's no demonstrations allowed around funeral facilities. But if you say, no demonstrations which would insult the people for which the funeral is, that would, for the US Supreme Court, that would be a violation of free speech. I don't know if you agree with me that, at least from a Swiss perspective, it's quite surprising. You would probably here say, well, it's the dignity of the deceased, you have to protect the family, their privacy at a moment of extreme grief. Not so according to the Supreme Court. So we have high-value speech, which is everything which is not low-value speech. Then obviously this raises the question, what is low-value speech? What do we put into this category? And for what reason? What's the criteria? It can't be just, I don't like it. And basically, this is a category which the US Supreme Court developed in a case called Chaplinsky. Chaplinsky versus New Hampshire. It was basically, I think it was a Jehovah's Witness who had an argument with a police officer, and he called him a goddamn racketeer and a damn fascist. So basically, you could say blatant insults. And there the US Supreme Court said that there are certain well-defined and narrowly limited classes of speech which in a way do not raise any constitutional problem. The question is why? The justification is that such utterances are no essential part of any exposition of ideas and are of such slight social value as a step to truth that any benefit that may be derived from them is clearly outweighed by the social interest in order and morality. This is where you see an approach of categorical balancing. You say these are types of expressions which as such we believe don't have much social, basically, social relevance, are not useful, and interesting social value as a step to truth. Truth comes back, our friend Mill and Holmes, etc. So these statements basically don't contribute anything to truth, etc. So they are off.
I don't think I quite understand why, in this case, the insults that this person made towards the police officer is considered to be have no social value, and yet they add social value to the homophobic demonstration at the funeral. Would that have any social value as well? Why is that considered to have social value, criticizing a dead soldier? And here it's considered to have no social value, criticizing
a police officer. It's a good question, and I think it all depends how do you frame the statements, right? I think that what the Supreme Court did was in the first case saying it was not just an attack on the soldier, it was in a way a contribution to a debate on homosexuality. It's because the statements were broader, homosexuality is a sin, etc. But I agree with you, it's really not easy to draw the line. What is a debate where you could still say it has some social value and it's just basic insults? We will read a case, RAV versus City of St. Paul, which is in a way about this difficulty. Should it still be protected as speech, or is it really no contribution to any debate? Now the question then is, what statements are not considered as having any social value? You can see there is an enumeration here. The lewd and obscene, so obscenity, which would apply to pornography, etc. You had a question.
Yeah, I think that I had the same problem. I thought, oh, well, you could just switch the statements around and would have the same result. It doesn't matter. But I think what stands out to me the most is the sentence or the part tend to incite an immediate breach of the peace, because I think we talked about this last lecture about the intention of the words, and if you try to create a danger for a person, and in this case, Chaplinsky was trying to do so, at least the court framed it this way, even though you could argue that, well, he also contributed to the debate of police forces being fascist or whatsoever. But I think just this tend to incite an immediate breach of peace seems to me like the strongest point of, oh, this is so different from the other case.
And just this, the bit you read that relates to fighting words. So fighting words is one category of low value speech. There's different ones. So there's obscenity, there's libel. Libel means defamatory. And the fighting word is the image. Are you from Germany? I think it would be a bit similar to Schmähkritik. To say basically what you're doing, a fighting word is, I insult you, and you just feel like punching back. Okay?
Isn't that the same? I think I'm not sure about the correct wording of the case before, about going to hell. Isn't that also some sort of fighting words of, well, you're homosexual, so you're going to hell? It seems to be on a very similar level, but it does not incite an immediate breach of the peace, because the person you're talking about, or the group,
Is dead,
is
yeah.
dead, so obviously they cannot act upon your words.
And I think it also links, in Europe you'd probably say Snyder versus Phelps, that's a form of hate speech, homophobic hate speech. And we could say that for us hate speech is a low value category, but not so in the United States. We will talk about hate speech. They will say if it's fighting words, hate speech which come across as fighting words, actually yes, but otherwise no. So if I have a website and I say the Holocaust has not happened and the Jews made it up, nothing happens to me. Okay. And it's then really this framing, it is like an ideological debate. And you have then also opponents saying this is actually not a debate sometimes, it's just attacking the other.
But then the first statement makes no sense of the court, at least in my opinion, where it states that which has never been thought to raise any constitutional problem, then it's just, oh, well, actually, we just think what we want to. There are no clear rules, even though they say they are pretty set, well-defined, and narrowly limited classes.
Well, I think their argument, you'll see it in the Brown case, is to say we have a long tradition, that certain categories of expression we consider are unprotected.
Okay,
Then
but then it's not well-defined, it's just made up on examples.
And what is also important is that basically, so we have Chaplinsky in 1942, but ever since the court has actually narrowed the significance of these low value categories. And maybe Snyder versus Phelps fits in there as well. So there has not been a trend to broaden what is not protected, but rather the opposite, to say we have here categories of expression which we still have to be careful that we don't interpret them in too broad a way. So we have here, these categories: obscenity, pornography, libel, fighting words, etc. And it is interpreted narrowly. So, for example, when I say something is obscene, not every swear word will be considered obscene. There's a famous case, I think it was where someone was demonstrating in front of, was it a court or a parliament in California, and basically had a T-shirt saying "fuck the draft," and he got convicted, was saying, "See, this is low-value speech; it's obscene, etc." And the Supreme Court said, "No, that's not obscene because it's political speech, and you can also, to get across that you're angry. Free speech also protects emotions, so you don't have to be very polite, etc." But you can see here we have a line drawing issue. Is it high value speech? Is it low value speech? So you look at the context, the purpose of the statement, saying the main thing. It wasn't like in Chaplinsky insulting an individual. It is to express a political view. I think we have deserved a break. We'll resume here after the break. I will show to you how these categories got more and more narrowed, and we'll discuss the Brown case as well. So we were talking before the break about high, low-value speech, and we already saw that this categorization is not always easy, that some might say debatable. I finished by saying that you have to interpret these low-value speech categories narrowly, okay? Like this case showed with the the draft. Then also to give you other examples of narrow interpretation, United States versus Alvarez. It was a case, and it's interesting when you read it, it starts off, lying was his habit. So someone who apparently had a vivid imagination and lied about almost everything. In that case, he lied about getting a congressional medal, which is awarded to people for extraordinary military efforts. And so he said he had that medal, and there's a statute which basically aims at protecting the integrity of the medal. So if you lie and you say you got it and you didn't, you got, I don't know, a sanction. And the US Supreme Court basically said that the question was, are lies, deliberate lies, low-value speech? The court said no, that's not within this category. And you have here some excerpts which show, I think, the tone also of the case law. So false statements, including lies, are not low-value speech, and saying our constitutional tradition stands against the idea that we need Oceania's Ministry of Truth. The remedy for speech that is false is speech that is true. This is the ordinary course in a free society. The response to the unreasoned is the rational, to the uninformed, the enlightened, to the straight-out lie, the simple truth. Truth needs neither handcuffs nor a badge for its vindication. So again, this idea of truth, which will emerge basically in a free marketplace of ideas. So if this guy says, I won a medal, well, others could say he didn't. And what do you think about that case? Would you have decided the same way? Or?
This is true, and another person tries to prove the other side. And last week we read this piece from Mill who said that the moment I say another opinion is not true, I claim for myself this 100% certainty, which is in many cases not really possible.
So you say it's not always easy what is true, what is false. Here, on the other hand, I think it was relatively straightforward. Did the person have a medal, or did he or she not have a medal? But I think where I certainly agree with you that it's not good enough to say something is false or it's a lie, that usually you would say you need to show the Europe, or the Swiss way to go about it would be, well, okay, if you want to limit an expression, you need a public interest or the protection of the rights of others. So, for example, defamation is a classic case. If you write on Facebook that, I don't know, my whole PhD is plagiarism, I would have a defamation case against you. You see what I mean? That you need some protected interest. Here you can say, is that such a strong interest to protect the medal as such? So the US Supreme Court basically said, well, the remedy, for example, would be create a database. Everyone can go and check who got the medal, who didn't. I think it also may depend what is the setting. Is it really part of a public debate? That's where we want to be careful. I'll give you another example. Think commercial labels. Would we say any company can say anything on their products? It's free speech, well, and the other people you go and criticize it. If you take it to the very extreme. Maybe one answer is also to say, well, if I go and buy things in a supermarket, I'm not entering, A, I wouldn't have the information, I can't really check, and B, I'm not in some, discussion on, it's not a scientific discussion on something, I'm making purchasing decisions, there's not a setting for debates also. But certainly a case which shows that you do not easily just create low-value speech categories, and you can see this idea of the free marketplace, like difference. You know, speech is the remedy, not sanctions. Counterman versus Colorado was quite a specific case. So basically the US Supreme Court says true threats are low-value speech. It's not initially on the list, but true threats, then also the question is, when do you consider something is a true threat, etc. This case was actually about stalking. So Counterman was someone who basically had already harassed his previous girlfriend or wife, and then he got obsessed with a singer, and he sent her thousands of messages on Facebook. On whenever she went, he would always, or she would block him, and he would create new accounts, and some of them were threatening. And so he got convicted under an anti-stalking law. And the Supreme Court basically said, well, that is labeled it as true threats, and said you can only basically convict someone of true threats if there is some subjective element. You need at least to prove that the person acted recklessly. So it's not good enough to say, we look at it from the singer's perspective, did she feel threatened by what he did, but you have to show that he was in a way reckless. It's a case which attracted quite some attention. Some said, well, it's just, you know, the court shouldn't have analyzed the case of stalking like that. It doesn't protect the victims sufficiently, because the crazier the person is and the more delusional, the more protection you will get, because the reckless element is not there.
But the fact of invasion of privacy wouldn't enter in this case. Like, wouldn't she be?
Yes, but the court will, if there is a conflict of rights, and if the court feels, you know, that it's about freedom of expression, often free speech gets more weight. So here the court didn't say, you know, you have now a license to go, that guy can spread all his messages. But what commentators said, stalking is still about repetitive. It's not one utterance, it's basically thousands of messages, and that there you should not insist too much on intent or simply protect the victim, say that's going too far. And it's also quite interesting, if I looked a bit at the deliberations, and there was also by Supreme Court justices sometimes some, I would say, statements not taking really the stalking very seriously, taking one statement and say who would get intimidated by this, but ignoring that basically if you get bombarded by thousands of messages by someone you can't get really rid of, it's intimidating. I'm just trying to see if I find one of the statements. One of the messages said, staying in cyber life is going to kill you. Come out for coffee, you have my number. And apparently Chief Justice Roberts laughed about it, saying he didn't see why that was threatening in any way, and even said he could have said something like that, not being a wolf. So I think if you're a cyber victim, a cyber stalking victim, maybe from a gender perspective, not the greatest ruling. But the point I'm trying to make here is that you do have an approach which might protect statements. We saw it with Snyder versus Phelps, so we might say, you know, why also isn't that going too far? Now you also read for today the Brown case, which is about video games, and a law in California basically saying for very violent video games that, you know, minors need parental consent. And now maybe we can do some brainstorming. What have you retained from the case? What did you find interesting, you agreed with, you may not have agreed with? And then we'll try and look at it more systematically. Who would like to say something about the case? Whatever you.
The court had, like, I would almost say, a really sassy opinion against the California state argument. And basically they held that, well, they had several things, but they were against, they ruled against the Californian state, and said that this was another step in a long and successful list of attempts to regulate violent media aimed at children. So I think there was really an element of being bored of the same old tradition, because the same thing happened. People try to pin violence or say that children being exposed to, like, for example, cartoons or violent music videos or music lyrics were also a problem that needed to be strictly regulated, and the court called this another this sort of attempt to over-regulate and did not agree with it.
So in a way, I think that was quite interesting to look at the history, you know, how when the media came out, when a new medium comes along, that there is a tendency to say, "Ooh, that is dangerous," you know, be it comic books. Who of us would think comic books are particularly dangerous, or movies, etc. And so the way the court puts this in this historical perspective and says, well, you haven't proven that these video games are worse. And, other elements you have retained from the case? What about if it had been a ratings system, the same system for pornography? Rating obscenity, maybe saying, you know, okay, yes, youngsters can see video, you know, maybe some nudity, some elements of eroticism is okay, but if it's pornographic, that they can't buy.
What comes back to these really limited areas in which people say, and says that video games don't really fit into one of the very limited areas, but if it was something with pornography, this would probably fall under one of these categories.
So I think from the legal point of view, one question was, are violent video games low-value speech or high-value speech? And if you look at this list, maybe I just go, that you see it, we have obscenity, pornography, that would be low-value speech. Libel, fighting words, well, violence is not on there. Now we may wonder, should it make a difference whether that was in the list of Chaplinsky in the 40s or not? What do you think? Should that be a relevant criteria to know if, you know, something is low-value speech or not? Or should we say violence is as bad as pornography? In the Swiss Criminal Code, I think there's two provisions. Pornography and representation of violence is one after the other. It's considered both as quite obnoxious or not.
It's just interesting that here it makes a comparison to other like films and movies about kids, like Snow White and like the Grimm's fairy tales, which also contain a bit of violence, so it considers it under inclusive, like the whole film.
Basically, just when we look at it from a more systematic point of view, the court first checks, is it high or low value speech? If it were low value speech, you could maybe say, well, it's not really protected speech. And there, basically, California could have got away with it. But once you say it's protected speech, then the court will look at, can you justify this measure? And there steps in your argument to say, well, they say it's under-inclusive and etc. We haven't proven that there is a harmful effect. But what do you think about the categorization issue?
Yeah, I think the thing was that they both agreed that they qualify for the protection of the First Amendment, as they said that it is a medium just like journalism or such is, and yeah, they said that the freedom of speech does not vary with new communication mediums.
So that, I would say, if you look at it systematically, even a step ahead, are video game speech. And that they said, yes, it's always the same principles, you know, the interpretation of the First Amendment has to adapt, I would say, to technologies. And so, yes, video games are speech. And so if they are speech, are they low-value speech or high-value speech? If it's about violence, not video games as such, but if we talk about the speech targeted here, violence, you know, you saw that one justice did some research, Alito, where he says, well, you dismember people, etc. And again, from a European perspective, if you see games, you play it ethnic cleansing. I mean, probably that would not be permissible to sell video games here where you play it ethnic cleansing also. High or low value speech? What's the reasoning here? Or what would you do? This case comes to you and the lawyers say, look, pornography has no value, no social value as a step to truth. That's what was said in Chaplinsky. Violence doesn't either. One is not worth more than the other. Yes?
I would have said maybe low value because of the fighting words link, and there's also that whole it's about the intent behind the words. And so if you like say use fighting words, but then with an intent to like cause harm to someone else, then that's kind of that was a sorry, I can't remember which case, but that was mentioned in the other case. And then this one, it's like about your play with the person who's committing the actions, and so that's kind of acting with intent to harm in a way, but even if it's in
And how would you what would be the harm in your view?
so
What would be the harm?
the harm, like for example, with the example just was made about the actions that you make in the video games and you're just manipulating things, and that all the ethnic cleansing that could be seen as harm because even if it's in a video game, the tip should still like.
And would you say the harm, it's the impact on the children, or would you say it's people knowing that you play at killing in a way it's a dehumanization of I don't know something? Or I saw other people raising their hand, but I don't. Yes.
I found the argument on comparing video games to books and movies kind of weak somehow. Because although it tries to say like books, you're reading the perspective of the character, so you're kind of leaving the character. The video game is more active, so like you're choosing the path you're taking, you're choosing what you're doing, so you have like options. The book doesn't give you options, so you're reading the author's idea, the author's creation, not necessarily yours. So I think that it shouldn't be considered such a strong argument to the court because it's kind of narrow somehow.
So you're saying that it is different? That was this argument raised, it's interactive, more interactive, you're more like an actor. That's a bit what you said as well. You're actually playing actively at killing. I think, again, there we are at the justification level. Then the question is also how much deference do you give, to the legislature? You could take an approach where you say, maybe we don't know so well. How dangerous is it? What impact has it got on children? I've read some statements, I'll give you the words straight away, that apparently violence is worse in films for small children than in a book because you present, the child makes a mental image in accordance with its stage of development. Whereas if you see something, maybe if you interact, I don't know. But then you would need, obviously, they try to do is find evidence and say this harms children, and they didn't find that conclusive. But this is, again, after once you said that it actually protected speech. And we're still a step ahead saying, is it even protected speech? Oh, I think you were first, excuse me.
For this argument, it actually put since the adventures of Hugh Sugarcane Island in 1969, young readers of Choose Your Own Adventure stories have been able to make decisions that determine the plot by following instructions in which page to turn to. So I personally also think that a video game is something entirely different than seeing or reading violence even in a choose your own storybook. But apparently the court didn't think so.
The court dismissed that argument.
So for the categorization, I think there's limited exceptions listed in the case, such as obscenity, incitement, and fighting words, which are low value or do not fall into the protection. And I believe that in the beginning they argued that the legislature cannot just create new categories because they do an ad hoc balancing where they say like this is more harmful than it is useful for the society, and therefore that is why like this video games argument or that is why video games qualify for the protection.
And I think that's a very important point you raised. So I think one perspective on this would be, well, you know, reason by analogy. Pornography is not worse while violence is not better. It's not so that's low value speech. The Supreme Court's perspective is different. It's to say we created these low value speech categories, and in a way you freeze them in time. You say, well, we will not add new categories, because if we do so, the whole reasoning tends to collapse with ad hoc balancing. Because each time you have an issue, you'll say, we just create a new category of low value speech. And so they come up with, they don't say that this list is exhaustive. They are a bit careful. They say maybe there is some category we haven't thought of, but there is a long tradition. You need to demonstrate there's a long tradition and that this is unprotected speech. And if you fail to do so, you will not add new categories. And the consideration is exactly what you said. It's about ad hoc balancing. You can see it in on page 66, the court, the left-hand column talks about, first of all, that you can't ban speech based on its content. There are some exceptions, limited areas, and it talks about traditional limitations. And already Stevens was a case about animal cruelty. Can you say that animal cruelty is low-value speech? And the court said no, because we can't add new categories of unprotected speech. And again, always still on page 66, that it's the quote you had on the slide from Alvarez, that it would be startling and dangerous, to add new categories of expression. So you need to show there is a tradition of limiting certain statements. And what was interesting also when you looked the way the definition of violence was, they actually got inspired from the US Supreme Court's case law on pornography, Miller versus California, where they defined pornography and they added, then the problem was, again, you have a definition problem. What is pornography? You might censor art, etc. So they added this saving clause, unless it has artistic and scientific, literary value. Not easy to apply, in my view. One justice once said in a case, I can't define pornography, but I know it when I see it. Okay, so someone was raising their hand, yes?
Yeah, I was thinking that even though the video game and the showing violence doesn't enter in the area of obscenity, pornography, or fighting words, it does enter the description that they give in Chaplinsky when he says that anyway, they don't give any social value and they don't bring us like a step closer to the truth. So they may not enter in the specific category of it, but they do comply with the second part of it, of the declaration, which they're not an essential part of any exposition of truth.
So in a way, it's not when you play on killing someone, you don't participate in any debate on what is, So I think the court had a choice. It could have reasoned the way you reasoned and said, well, look at the rationale of this. Violent video games simply don't contribute anything, so we expand the list. But the US Supreme Court did not want to do this because it does not want to have this balancing approach. In a way, we are now with categories frozen in time. Okay, they can be narrowed in the case law, but the court will be very reluctant to expand them.
But at the same time, when this list of low speech values was created, they could not have predicted the creation of video games or the type of violence that can be shown in these video games or in films, or even back then, I think they had a very different definition of pornography than we have today.
It's an argument you could make, that you could say, well, it's in a way too, there's also, we will talk about an interpretation too originalist. You stick too much with, historical interpretation, but I think it's, whatever we think about it, we can be in favor or against. I remember one of our former rectors actually met Scalia, who wrote the opinion, and told him he was in the medical faculty. He just said for him this made no sense. Scalia got very upset, saying kind of you didn't understand what we did, etc. So it was interesting to have this conversation. But what I think the main point really is you have to understand the rationale, whether you agree with it or not. You cannot create new categories, because the court is afraid that will give a kind of ad hoc balancing system. So we're in a way stuck with what the court said in Chaplinsky, unless you show there is some long tradition for some categories that one has thought of. Then comes the question as it's protected expression, well, which shows that, it can be high-value speech even if it's not political speech or anything. It's the residual category. Can it still be limited? And that gets me, before we look at that, against another important distinction. I'll be there in a second. We will see in further cases that the court basically has relativized also, in a way, constitutionalized some expression which is low-value speech. And also what makes it more complex, there's also some intermediary category which was created later, commercial expression. When I talked about, labels on commercial products, etc., the Supreme Court would say that's commercial expression. That is somewhere in between. You can regulate it but it has to be true and not misleading to deserve constitutional protection. So these labeling schemes would not be an issue. But here is the other important distinction you have to know. It's basically the court will categorize the state measure. The major distinction is the speech restricted because of its content or the viewpoint which is expressed, or is it a so-called content-neutral restriction? They are also called time, place, and manner restrictions. Maybe to start with that category, content-neutral restrictions would be restrictions which regulate the time, when you can say something, where, and in what manner. I'll give you an example. We will not allow the use of megaphones at demonstrations within 300 meters around hospitals after 8 p.m. So you could say, well, we regulate the time. We don't, after 8 p.m., we understand the rationale. People in hospital should be able to rest and recover. No megaphones, it's the means and the place around hospitals. But it doesn't matter whether you want to convey whatever speech you want to convey. It doesn't say it's if you demonstrate for the environment or against it. It applies to all kinds of, it's independent of the content. It targets the time, the place, and the manner. This is an important distinction, so also for the exam. I can ask you, give me examples, explain what that means, content-neutral, content-based. Content-based restrictions are restrictions which actually you have to know you have to know the content of the speech to know whether they apply. Typical hate speech, if you say, speech which incites, for example, to violence, to hate and discrimination against, based on color and ethnic origin, sexual orientation, that would be a content-based regulation because it targets speech because of its content. And for the US Supreme Court, these content-based restrictions are basically very suspect. They interfere with the free trade of ideas. They favor one side. It's not up to government to say what is the right point of view, what subjects should be discussed. And then basically, if you have a content-based restriction or viewpoint-based restrictions, hate speech would be the viewpoint-based because it would basically say it's one ideological viewpoint. That's how the Supreme Court views it. It's about saying some races are inferior and the opposite point of view, that all people are equal, that is not regulated. That is not targeted by hate speech. If it's a content-based or viewpoint-based restriction, basically, you could still, in theory, justify it. It has to be necessary to serve a compelling state interest that is narrowly drawn to achieve that end. So it's strict scrutiny, very exacting, compelling. Compelling is important. It's not just any legitimate interest, narrowly drawn. And basically, as scholarship says, it's strict in theory. You get the impression I could still justify the measure. but fatal in fact. In reality, basically it's hardly ever you will succeed in convincing the court that a content-based measure was justified. We will see it when we'll talk about hate speech. So generally the court will just say, you find some other means than limiting speech, as it did in Alvarez or whatever with the lie. Find some other way, create a database, don't limit speech. If we have content neutral restriction, you still have to justify it, because I mean you could also, via content neutral restrictions, you could still limit speech quite a bit. So, but here you see you don't need a compelling state interest, a legitimate government interest. And the regulation is rationally related. It's not narrowly drawn. So here it's more intermediate scrutiny. You have a chance of convincing the court that this time, place, or manner restriction is justified. If we return to the Brown case, so basically the court applied this test, the content-based test. So you have to basically show that there is a compelling state interest and that it's narrowly drawn. And within that, you could see that the court, how strict the review is. It's also, first of all, it's up to the state to prove, it's not just has to be likely, that these video games have a bad effect on children. Causation, says the court, you have to show it's the cause. Anyone who has a scientific mind knows it's not easy to prove causation. Correlation, we can prove, we do sample studies with children. These children who watch and play these games, what is the effect on them? Do we really know it's causation? It's so obvious. So we can see the court is very strict, because in as much it will not give deference to the government, say, okay, if it's somehow plausible that it might have a bad impact, it's not good enough. So you would really have to have very strong proof that there is a strong impact on the children. So that proof already did not succeed. Based on the arguments which were mentioned, we've always had different kinds of violence in other media. And apparently the studies here were also, apart from that, not very conclusive. And then comes this also, it has to be narrowly tailored. Some of you already mentioned the argument, it's under-inclusive, over-inclusive, very hard to get it right. What did the court say? It basically said, so if there's two interests which were advanced. One is to say we have to protect children. So if you're being serious, so you would have had to target all the other things as well. You didn't, so it's under-inclusive. And then the other interest advanced was, well, it's the parents. Parents have their say, and if parents don't want their kids to play at these games, so basically then we should give deference to the parents. And the court says that's over-inclusive because some parents may not care. So you target all the parents, even those who don't give a hoot about what their children play at. So I would say that really shows, to get it right, narrowly tailored enough, and to convince the court that it was a compelling state interest, generally you will not succeed. It's a good illustration. In theory, you could have justified the measure, but in reality, it's fatal. So here you can see how important the categorization is. Is it high or low value speech? Had it been low value speech, the state could have regulated. And then is the measure content-based or content-neutral? If it's content-based, virtually no chance of justifying it. Any questions on that? It's a different approach, I think, than what you may know from other. Yes?
For the Czaplinski categorizations, are they set in time in terms of interpretation as well? Because we can see in Brown they reference the Miller case in which obscenity was kind of interpreted to mean sexual conduct, but any of those terms could be interpreted in a variety of ways. And that was in 1973. So, could in the future the terms be reinterpreted to include violence in other ways?
Violence, I'm not so sure after what they said in Brown. But I mean, when you look at the definition of pornography, it does refer to community standards. And so I think that is evolutive. because the community standards of what is, you know, obscene, and it's about the prurient interests of whatever a community, that will depend obviously over time. So I think some of the standards, you can't just say, well, we will now say pornography is what was pornographic in the 70s or in the 40s. So it depends maybe on each category, and defamatory, I think maybe less evolutive, but maybe some evolution as well. What do we think is defamation or so?
If not like being able to broad what we include in the list, but for example, in the case of pornography, we have the Miller test.
Mm-hmm.
So it would be necessary a kind of test as well where we can manage or see the level of violence that is shown to the kid. For pornography, it was quite clear. It's like, oh, what's the interest? Is it offensive or not? Does it lack serious value or not? And I think that now, as someone mentioned before, with video games and everything, violence could enter in similar tests like this.
The court will just refuse to do so. It will say, I refuse to add a new category. I will not expand the list of low-value speech. I mean, we heard other arguments saying, well, video games didn't exist, and we should refer to the general definition of low-value speech, that it doesn't contribute to the truth or so, but that's not what the court does. I think the only chance you would have is if you have extremely serious studies, and probably a broad consensus, because you can always find other studies, saying that we have demonstrated now that there is a strong harm on children. And then you would have to make sure, how would you, you know, and you would probably have to demonstrate that it's specific to video games, otherwise you're again under-inclusive, etc. And that's not easy, I would say, to show. Because otherwise, says the court, there is always the risk you will censor certain ideas. You have in the case appearing this idea, we don't want content-based restrictions. Censoring violent video games is based on content because it's violent. And then they make this analogy where I think, again, no European court would write that. Basically, the danger of the California Act is that the ideas expressed by speech, whether it be violence or gore or racism, and not its objective effects, are the reason you ban it. We would never say it's racism, you know, that is an idea out there like any other idea.
When I hear this statement, and I've thought that already, something slightly unrelated, how do they manage the book bans in certain states currently? Under which
I think the problem is, you know, that a lot of these laws measures have not been challenged. I'm sure if it were challenged, you know, that the US Supreme Court could not uphold it. I don't see how they could uphold it. And that is really the difficulty, or that you have a lot of restrictions now. I think if you look at the Trump administration as a whole, it's using money. It's saying, you know, we will sue you, or with law firms as well. Basically, it's using this, or with universities. You will not get subsidies. You will not be able to receive foreign students. And I think as there are so many measures, it takes time. Are they challenged in court or not? And then it takes time for them. But if I remember, but I have a doubt now, that the piece I've given or I've uploaded says that, yes, a lot of these things are against the First Amendment, but they are not being challenged. So we have quite a few. Okay, that's it.
Then if you, say for example, would that hold in a court of law? You say, well, that's a restriction on your speech. Oh, it's been no access to screens and obviously television entertainment of children until a certain age. But then under that, then it's kind of it's applying to all the potential information sources we could get from that.
I think a 2-year-old, it would maybe be less about information. But more than it would be about to what extent can the state prescribe, you know, what parents do with their children. China has a strict law now, I think, that about video games. And but again, here it would be banning all the games. It would not be, violent games or also
All television programs even.
or television. Maybe I think would be more a debate also about, how old are the children, and about a liberal argument. It's not up to the state to manage this. I think there were two people here. So yes.
Yeah, just to add to what he said in regards to the books, does the same apply to music as well? Because I know like music has like a whole lot of all this. It has violence, it has some absurd words, it has some pornography in it as well. So if it applies to books, how about music?
Music is protected as well, like movies, etc. Any means, freedom of expression protects anything which has a communicative. I would say it's more, does it bring across some message? And can it be understood as such, from if you're the addressee of that expression? And sometimes with art, it's not always so clear. It's not necessarily a rational message, but you do want, and I mean, often artists do get censored quite fast because they can be subversive. Look at if you want interesting, the Pussy Riot cases decided by the European Court of Human Rights, which they challenged Putin and so on. There was someone else? Yes?
Yeah, just on the book ban thing, I think they're trying, like the legal strategy that the people who want to ban books are trying to use is that, like one of their aims is to remove books about LGBTQ plus people from schools and local libraries. So they're trying to like redefine obscenity and trying to include like young adult books that have LGBTQ plus characters and like say that they're obscene or they're looking for anything that could be perceived as pornographic in order to like kind of like push these book bans through.
But also, there's quite a bit of case law about what is pornographic, and the Supreme Court is relatively strict, so it doesn't admit so easily. You can't just say anything. I don't think it would stand up. But and there's also other books. They banned Hannah Arendt, George Orwell, 1984. I mean, those are, you could say these books are. But it's interesting what you say about the strategy used. I just don't think it would be successful. So maybe just we may not be able to do everything. Just there is some, you don't have to read these cases, I will not ask you about them, but I've just given a few examples of content-based restrictions. Interesting is there was quite some debate because the states would put in place restrictions around abortion facilities, saying no demonstrations around, let's say, 300 or 130 meters around abortion facilities. Is that content-based or content-neutral? And basically in Hill versus Colorado and in the next case, McCullen versus Coakley, the Supreme Court said it's content-neutral. But there was the conservative Scalia was in the dissent saying, well, actually, no, it's content-based because obviously it targets speech of people who is pro-life. But that's not what the Supreme Court decided. That's why I said with this Feld case, you would need a law saying there's no demonstration whatsoever, around funeral facilities. So you target everyone. Doesn't matter why you go and demonstrate. Even if in reality you might say we want to protect mainly against demonstrators who would go and insult the family. So you can see that the distinction between content-based, content-neutral maybe can be tenuous because you will